My name is Justice Raymond Ikola. I'm a retired justice from the California Court of Appeal and now a neutral at JAMS, where I've been doing arbitrations, mediations, neutral evaluations. The first thing you should do in a mediation, I think, is to listen. It's very important to listen to the parties and begin to understand what their situation is and why they feel strongly about their case. Try to put yourself in their shoes. I think that is a part of the process in gaining their trust, that you're not here as an adversary. The mediator is not a decision maker. The mediator is not going to decide their case. The mediator is going to do his or her best to bring the parties together and to resolve a problem in their lives. What makes up a good arbitrator? Well, I think first of all, to be well studied in the law. I think it's important to always hew to the law as you understand it. Also, do your best to understand the factual basis for the dispute. But every case is different, and some are factually intense, some are legally intense. Sometimes in arbitration, it turns on a legal issue or an interpretation of a statute, the interpretation of some case law, and sometimes it's very much dependent on the parties' respective positions factually. I've spent over 18 years in the California Court of Appeal, and the thing about that position is you hear every kind of case that's disputed in the Superior Court. Whether it's juvenile dependency, delinquency, whether it's probate, whether it's mental health, they all interest me. Most of the neutral evaluations that I have seen have been preparation for a hearing or a briefing at the Court of Appeal. So certainly I think if the parties think about it before they even commit pen to paper to write their briefs, it would be helpful, I think, in many cases for them to get a neutral evaluation of the facts of the case, to take a look at what happened in the Superior Court and to suggest ways in which either the decision can be affirmed if that's their position or reversed if that's their position. Mediation can be very helpful, I think, if the clients are willing and able. Parties have to want to do the mediation. I like to describe the legal dispute, as a problem to be solved, and try to bring the clients, but the parties particularly, into that frame of mind.